two of you together is just
Dynamic duo, right?
okay.
Today's courtroom docket starts quietly, but multiple defendants are about to face very different outcomes. From bond decisions to plea negotiations, every moment matters. Watch closely as routine hearings slowly turn into tense legal decisions. Subscribe, like, and share for more dramatic courtroom breakdowns and real legal stories from inside the courtroom.
Your Honor, the people believe any potential conflict between this honorable court and the office of the public defender, while the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, sir.
Morning, Judge Torshio Feaster, first assistant public defender. We likewise do not believe that a conflict exists, but should a conflict arise, we will waive that conflict and ask this honorable court to please hear all matters before today.
Thank you. The court, for its part, also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Angelo Andrews.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Attorney Eric Chappell on behalf of Mr. Andrews.
Mr. Andrews, can you state your name, please?
Angelo Antonio Andrews.
Thank you.
Thank
All
you.
right. What's wrong? Their arraignments. And counsel, are you appearing on both cases?
Yes, Your Honor.
All right. So as to the arraignment, your waive formal reading and your client stands mute.
We do, Your Honor.
But in having waived formal reading standing mute, the court will enter a not guilty plea on his behalf. Today's the 4th.
Okay.
And where do we want to go from here?
Your Honor, we have submitted a offer to the prosecutor's office, hoping to potentially resolve the matter. Mr. Andrews drives for a basement waterproofing company. This is not like an over-the-road carrier or anything such as that. We're hoping that we might be able to resolve it through the payment of some overweight fines and some civil infractions rather than misdemeanors. These are light duty dump trucks. On the day in question, just so the court has the context, there was heavy clay.
I don't know that I need the context.
Okay. Yep. Gotcha.
Do you want me to adjourn this so you guys can talk?
That'd be fine,
Yes,
Your Honor.
Your Honor.
Thank you. Yes.
Mr. Chappell, if you could just confirm what email you sent that to. I don't see anything in my inbox, but I can give you my email so we can talk directly.
Yep. Go ahead and give it to me. I know it was like I know it was an SA email as I was looking through the file earlier.
Yeah. So my email is cookr, COOKR @washtenaw.org.
Will the 18th give you enough time or you guys need more time?
Your Honor, I think that would give us enough time.
During this matter to March 18th, 2026, 9 a.m. as your invite indicates. I'll set the defendant's bond at $5,000 personal recognizance bond, standard conditions, including no assaultive behavior or use of any weapons. All right. Thank you.
Thank you, Your Honor.
Calls the case of the people versus Aaron Williams.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Williams, who is approaching.
Just an arraignment.
Could you state your name for the record, please?
Aaron Williams.
Thank you, Your Honor. At this point, as it regards arraignment, we would waive formal reading, stand mute.
And in every way, formal reading, standing mute, court will enter a not guilty plea. All right. What are we doing?
Your Honor, regarding bond, Mr. Williams is the father of 4 children. He works 2 jobs. He understands testing is going to be part of moving forward. The SoberLink and random testing do not work with the schedule of that is imposed because of the children and the jobs. So he's requesting a tether to test moving forward. We have a very low BAC in this case, but there is a prior from 2019. And Mr. Williams is
What is the alleged BAC?
0.083, Your Honor.
Thank you.
Bond in this case will be set in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or ammunition. There's to be no use of alcohol, illegal drugs, or any recreational marijuana. I will order that the defendant is to report to community corrections for placement on a scram testing unit. And then I will adjourn this. How much time did you need?
Your Honor, if we could get 3 to 4 weeks, we do have several videos, I've been told by my staff. We have not seen those. I've not had a chance to review the video evidence.
Adjourn this matter to, yeah, Joe Hall showing up on this date. That'd be about right. April 1st.
Funny enough, Judge.
26.
Well, Judge, the issue there is I am
What is
to
it?
be
National holiday for you. Right?
Orlando.
No.
Yeah, exactly, right? I think,
Yeah.
Your Honor, I think the world is fooling
Don't
me
shake
that
your
day.
head, it's a holiday. Go
Yeah.
ahead.
Your Honor, I think the world's fooling me that day because I've been lured into going to Disney, and I will be,
Oh, Joe.
suffering in my own way, but I'll be out of state, Judge.
Oh, well, when you go, say hi to the mouse.
I sure will, Judge.
Really, not for me, for Ann. I don't understand the mouse.
You know what? I'd rather.
But if you see Donald, him and I are more, we have much more in common.
And Your Honor, on the 8th, I'm in actually Charlotte, Michigan, in
I
person in
think
the
it's
morning.
Charlotte, but that's okay.
They tell me Charlotte. I don't know.
No,
to be honest.
right.
I wish
I think the way you said it is correct.
I wish I never had to learn, Judge. I already regret some things about that
Wow.
one.
April 15th.
That works for my calendar, Judge.
April 15th, 2026, 9 a.m. Bond will continue as said.
Thank you, Your Honor.
Thank you.
Good to see you, Judge.
Good to see you. I really do like the mouse. I do. We have issues at times. Court does call the cases of the people versus Byron Blair.
Morning, Your Honor. Raymond Cook of the People.
Good morning, Mayor. Police Court, Your Honor. Attorney Damian Cass, P number 85852 on behalf of Mr. Brian Blair.
Blair, can you state your name, please? Do you hear?
Right here, the defense asks for an adjournment while waiting on treatment information that could support a deviation request. That's a strategic move. If the defendant shows commitment to treatment, judges sometimes consider more lenient outcomes. But it also signals the case isn't ready yet. Do you think this delay helps or hurts?
Yes, Byron Blair.
Byron Blair, thank you.
Ron Brown appearing on behalf of Mr.
All right, what are we doing?
Your Honor, on my matter, I am asking just for a brief adjournment to potentially the 18th or the 25th. I am seeking some information from a treatment facility that I have yet to receive so I can submit a deviation letter. And also asking is if the current potential offer for the 1-for-1 is still open.
The offer that was previously extended for 1-for-1 will remain open as long as the defendant remains compliant on bond.
I would join in the motion to adjourn.
Turn these matters to April 18th,
April 18th.
2026, 9 a.m. Thank you.
Thank you, Your Honor.
March 18th, I'm sorry, March 18th.
March 18th, okay. All right. Thank you.
All Joe Hall's fault. Court calls case People versus Paula Johnson.
Raymond Cook of the People.
Oh, no. Hold on. It's my worst nightmare.
Good to see you too, Judge.
Absolute worst nightmare. It's just,
Always a pleasure.
No, well, it's kind of a nightmare.
Okay.
It's like a very, I won't call it a nightmare. I'll call it like a really scary dream.
Understandable.
Okay. And that's.
I get it.
Go ahead. You guys state your name. The two of you together is just
Dynamic duo, right?
Okay. That's
I don't know, is that bad or good?
Of all the
Paula
attorneys,
Johnson.
thank you, of all
Yes,
the
sir.
attorneys you could get.
It is her lucky day. So, Attorney Hugo J. Mack, Your Honor, appearing with Ms. Johnson, dynamic duo, Thomasina.
This is now gonna take a turn.
A good turn. It's,
Well, I don't know. I'm just
You
saying,
don't know.
we don't know.
you know, Mr. Cook has come up with a brilliant idea, and my client is fully willing to comply if the court will allow it. So there's a possibility here, if Mr. Cook agrees to enter a deferred sentence on this matter, Judge.
All right, is she gonna plea? Is that?
Yes.
Do I have forms?
No, Your Honor, I'm filling it out right
Okay. So everything's not done. You didn't let Mr. Cook know that's what you were doing.
Well, he knew, but he was so busy. They're so
Okay.
they're so overworked in that.
All right. So what I'm gonna have to ask you to do, has she signed an advice of rights form? She's
No.
not done anything.
No.
Yeah, dynamic, just dynamic. Listen, I'm gonna pass it. Let you get all the forms filled out, then I'll call you back up.
Appreciate it.
Okay.
Thank you so much,
Thank you.
Judge.
No, that's not my fault, right?
What?
I said, that's not my fault. They didn't give it to me.
No, I know nothing is ever your fault. We've been through this before. Court calls the case, people versus, is it Zeke Church?
Morning, Your Honor, Raymond Cook with People.
And Judge, good morning to you and the staff. Vincent Haysha, with and on behalf of Zeke Church, who's present through Zoom without objection.
Church, can you state your name, please?
Zeke Church.
Okay. And what are we doing? Are we entering a plea today?
We are.
Let's get my forms here. Forms I have before me indicate that the defendant will be pleading guilty to the charge of disturbing the peace, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There is also a sentence agreement of prosecutors deferred. That's a court's full understanding of the agreement.
That's correct, Your Honor.
Ours as well, Judge.
All right, very good. Church, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please, sir.
Zeke Church.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
I'm trying to get to the court. It won't let me get to.
Well, can Motorola, can you? Thank you. So, sir, just because we had an interruption there, you understand the maximum penalties, is that correct?
Correct. Yes.
And understanding those penalties, do you still wish to plead guilty?
Yes.
And to that charge?
It's a done.
Okay. Whoever, one more time for the person marked Motorola, and then I'm just removing you from the courtroom. Sorry about that, Mr. Church. So, Mr. Church, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct, sir?
No, I don't think so.
Zeke, this is the form that we went through that you gave me permission to sign.
Yes.
Okay. So you caused it to be signed on your behalf. Is that correct,
Yes.
sir?
Correct. Yes.
Do you have any questions regarding any of those rights?
No.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of March 29, 2025, at the location of 4095 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do that makes you think that you're guilty?
May I voir dire, Your Honor?
Yes, you may.
Mr. Church, that location that the judge just mentioned, was that better known as Besting Games in Pittsfield Township? At least to you? Mr. Church, can you hear me?
Yes, sorry. Yes, Besting Games.
okay.
Yes.
Okay. On that date, were you present at Besting Games?
Yes.
Did you engage with two individuals that you did not know?
Yes, I did.
And while you were engaging, that involved some pushing and shoving?
Yes, I did.
And that happened, you'd agree, in front of other people in the general public?
Yes, correct.
And who of course, observed this. Is that fair to say?
Yeah.
I'm
Public
satisfied,
did.
Your Honor.
All right. Would you agree, sir, that disturbed the peace and repose of the immediate area surrounding where you were?
Yes.
This is the critical moment. Zeke Church openly admits to pushing and shoving during an argument in a public place. That admission satisfies the legal elements of disturbing the peace. Once the judge hears this factual basis, the guilty plea becomes valid. From here, sentencing and probation recommendations become the next major step.
Sir, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Understood.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Well, yes. Defendant is referred to probation for pre-sentence recommendation and consideration of prosecutor's deferred. Sentencing in this matter will be
April 8th at 9 a.m.
April 8th, 2026, 9 a.m.
That's great, Judge.
Bond with its conditions will continue. Do I have probation? I do. Mr. Church, I'm going to ask you to remain online. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay, sir?
Okay, thank you.
Thank you.
Thanks, Judge.
Thank you. Court calls the case of the People versus Taylor Chapman.
Your Honor, ready to cook for the people?
Ron Brown appearing on behalf of Taylor Chapman, Your Honor.
She here. Oh, there. Ma'am, can you state your name, please?
Taylor Chapman.
Thank you.
Your Honor, I'm requesting a brief adjournment in the matter. I wasn't able to talk to her.
Okay. Ma'am, I'll adjourn your matter to March 18th, 2026, 9 a.m., or as your invite indicates. And do you have phone numbers and connection information, or does she need to call the?
Please call our office.
All right, ma'am, if you could call the public defender's office and just make sure they have your correct phone number and email.
Okay.
Do you have that number?
Yes, it's on the letter.
Okay, very good. Okay, thank you, ma'am.
Thank you.
Court calls the case, People versus Carlton Cross.
Your Honor, ready to cook for the people?
Ron Brown appearing on behalf of Carlton Cross, Your Honor. Mr. Cross, are you on the call?
Not checked in.
Not checked in.
Oh,
Or is he here?
He might be able to.
What's your
you hear
name,
me?
sir? I can hear you. What's your
Carlton.
name?
Sorry about that, sir. Carlton Dion Cross.
Okay, he's here.
Your Honor, I'm requesting an adjournment after March 24th. He has a circuit court pretrial that date, and we're trying to resolve the case. He was not accepted into the sobriety.
He was not.
He was not.
April 1st, 2026, 9 a.m.
I'll be in touch, Mr. Cross.
Bond continued. Thank you, Mr. Cross.
Thank you. Thank you, sir, Judge.
Yeah. Cross case, People versus Shamika Kurtendahl.
Morning, Your Honor, ready to cook for the people?
Ron Brown appearing on behalf of Ms. Kurtendahl. Ms. Kurtendahl, are you on the call?
Yes, hi, good morning.
Good morning.
Your Honor, I'm requesting a brief adjournment.
In the matter, March 18th, 2026, 9 a.m. Bond continued.
We'll be in touch, Ms. Kirkendall. Thank you.
Thank you, ma'am.
Okay, thank you.
Court calls the case of People versus Ishmael Davis.
People,
Ron Brown appearing on behalf of Mr. Davis, Your Honor.
What? Hold on a second. Why are you telling the baby to be quiet? No, tell Feaster to be quiet. That baby can talk all it wants. I was only hearing Feaster. Apology accepted. All right. What are we doing in this one?
My last notes in the file indicate I believe he was in treatment, Your Honor. I tried calling him last night and got a hang up.
Okay, he's still in treatment.
I haven't verified that, but that was my last note.
All right, but do we know where he's in treatment?
No.
We don't? You just have a note that he's in treatment?
Yes, Your Honor.
All right, well, if you verify that, then fine, but at this point, I'm gonna issue a bench warrant for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Will you hold at least to the end of the docket?
No.
Okay.
I mean, if you get the information, we'll take care of it. But court calls the case. People versus, is it Comaria Davis?
morning, Your Honor, may we vote for the people?
Ron Brown appearing on behalf of Mr. Davis.
Good morning. What's your name?
Tamaria Davis.
Thank you.
Your Honor, she will be pleading to an added count to a retail fraud in the third degree, and she is eligible.
Do I have the forms? I don't have anything.
Coach, Your Honor?
Well, if you have plea forms, I need them. Do I have an advice of rights signed by her?
Here's a plea form. And here, I have an advice of rights. Can't find it right now. But I thought.
All right.
It's over electronic. Okay.
We have nothing. Let me pass it, look through an advice of rights, get it to my staff, and then I'll be more than happy to take her plea. Okay, thank you.
And just like that, the courtroom shifts from routine hearings to serious consequences. When the court cannot confirm a defendant's whereabouts, a bench warrant is issued immediately. Missing court can escalate a case fast. If you enjoy real courtroom breakdowns and legal drama, like, comment, and subscribe for more shocking courtroom stories.